Welcome to our estate planning seminar here at Pine Castle. I'm Charlie Myers. I'm the lay leader here. And we've got a couple of experts here today to help us with various facets of estate planning. God has called us all to be good stewards of that which He's given us. And so today we're hopeful that each one here will get a few additional nuggets to help in being good stewards of what God has given us. We're privileged today to have Lynn, Aust, an attorney here in Orlando who specializes in estate planning, and Keith Haskell, a member of the church here who is a certified financial planner. And together they'll cover many aspects of estate planning. So one change from the instructions, both said they're comfortable entertaining questions as they move along in the presentation. So if you have questions, feel free to ask those, and answer them too if you can. But feel free to ask those as we go along, and then we'll have a short period at the end for any other questions. So with that, let's begin with prayer. We thank you, God, for this day, the many, many blessings that you've poured out upon us. And we ask you, Father, to come in and be in charge of this time together and show each one of us those things that you want us to learn and to apply in our lives. We give you thanks for those that will present today and ask you to bless this time in Jesus' name. Amen. Lynn, thank you.
Is it still morning? Yeah, good morning. It is so exciting to be here. I love Pine Castle, and there's so many people that are familiar faces, so thank you for the good turnout. I've done a lot of these presentations, and I love to walk all over the room and make sure everybody's awake all through the whole thing. I can't do that today. So if you see me sitting here about to explode, you know why, because David wants me to stand right here. So I've had several questions visiting with you all. I'll try to hit them all. Please interrupt as we go. So if you go to the first slide, this is about estate planning. That's probably, in my opinion, a misnomer. This is probate avoidance. We are planning our estate. Our estate is our assets. If you have more than car and clothes on your back, you have an estate. People say, well, I don't have an estate. You have life insurance. You have an IRA. You have a savings account. You have a checking account. You have an estate. And when you pass, if it's only in your name, that's probate. You can go to the next slide. What is an estate plan? That's the documents we set up. Forget that. It's the documents we set up to avoid probate and to ensure your wishes are covered. This is both your wishes, God forbid you become incapacitated, meaning you can't direct what you want for your health care, for your finances. And also, who gets your assets when you pass? You can go to the next one. The benefits of doing an estate plan, the biggie used to be probate avoidance. We have a lot of fraud on seniors, a lot. I deal with it every single week. I'm sure every one of you here knows somebody who's been taken advantage of in their golden years. As we age, we become a target. So by doing some steps now, before we get to that place, we're protecting not only our assets, but our legacy, our children's inheritance, and especially if we become incapacitated. You can go to the next one. Okay, probate. What is that? That's the court process of taking Marcia's assets after she passes and putting them where they need to go. She's directed in her will or her trust. If Marcia didn't do, I'm picking on you, if Marcia didn't do a will or a trust in advance, the state has a will for her. The state has a will for every single one of you. It may be exactly what you want. 9 times out of 10, it's not. So it's so much better to put your wishes in writing in a binding legal document. And who's going to be in charge? That's the big issue. If you do not have a will in place and you've got siblings or kids that don't get along, you're going to court to duke it out, or they are. You'll be in heaven hugging Jesus. Next slide, please. Okay, unfortunately, most of us don't think about estate planning until we're towards our senior years. Our little snowman, Mr. Snowman, it's March. It's time to talk estate planning because Mr. Snowman's going to melt. Y'all are here. This is good. This is the time you need to be planning and telling your neighbors to plan and telling your children, your adult children, to plan. I can't tell you the number of 25-year-olds I talk to about if I know you don't have a big asset level, but you do have something and you want to ensure who's going to take care of you if, God forbid, you become incapacitated. So, next slide, please. These 4 documents are the 4 basic documents in an estate plan. We're going to go through each one, probably your eyeballs roll back to the back of your head. But I want you to understand, Keith and I are here today. I'm going to do a little bit of a sidebar here. Keith and I have been friends for almost 30 years, and we share a lot of clients because we're both interested. Y'all are people. You're not dollar signs. We're going to recommend for you what, in our opinion, is best for you for finances, for accounting, and for me for estate planning, probate, and guardianship. It's very difficult in this day and age to find professionals who are looking at you as a person, not a dollar sign. But, caveat, we're not here to get your business. We're here to open up your heads and pour in a bunch of information in your heads, and then you go find your own financial planner and your own estate planner to make it happen. You ask good questions. However, Keith would be my choice because he's a man of integrity. He's not going to sell you an asset because it lines his pocket. He's going to recommend an asset because he thinks it's a good, sound decision for finances. So enough of the commercial for Keith. 4 basic documents for estate planning. The first 3, durable power of attorney, healthcare surrogate, and living will, those are while you're alive. They help you while you're alive. It names who you trust to handle different aspects of your life that you can't do. The bottom one, last will and testament, that helps you after you're gone. So the first 3, you'll hear them called advance directives. We call them incapacity documents. That's, God forbid, if you become incapacity, those 3 step in. The top one, durable power of attorney. This is not the same as a power of attorney. A power of attorney is where I tell Peggy, I'm going to be out of town. I need to close on a piece of property. I'm going to issue a power of attorney for you to handle the closing. That's for one single incident, and it's only while I have clarity of mind. And when her job in that is done, the document's done. Durable power of attorney means if you become incapacitated, and by that I mean a doctor says you can't handle your finances, or your family has clear and convincing evidence that you can't handle your finances, then whoever you've named in that document can step in and help you with financial decisions, pay your bills, make sure they're dealing with Social Security, that the payments are still coming in, or retirement, that the payments are still coming in, or put the new roof on the house because it's leaking. All very, very important things if you become incapacitated. Same thing for healthcare surrogate designation. God forbid, you become incapacitated and you cannot make your health care decisions. Now, the hospital's always going to look to you. Your doctor's always going to look to you to make your decisions. But if you can't, then you've named somebody in your documents who's going to step in, who you trust. Living will, end-of-life document. Living will is not a do not resuscitate. Do not resuscitate, and I get this question all the time, that's in a crisis situation, in a hospital, where the doctors and medical staff come to the family and say, not likely to make it, do you want us to resuscitate them if they flatline? That is in a crisis situation, and you're not making the decision. Living will is in a non-crisis situation where you're going, okay, if God forbid I'm in one of these 3 scenarios and I'm hooked up to life support, do I want the life support continued or removed? So it's a very big distinction between living will and do not resuscitate. We'll go into more later. And then last will and testament. I get asked this question a lot. I'm not going to have probate because I have a will. No, the last will and testament is the roadmap to the probate court who gets your assets. It doesn't avoid probate. There are other things that do, and we'll get into that. Keith's got a bunch on that, and I've got a bunch on that. So 3 documents for incapacity, 1 document for after you die. Next slide, please. And if anybody got questions, interrupt. I'm okay with that. Yep, okay. We already went durable power of attorney. Who do you name? First off, you're not going to name 3 people with equal authority. A bank will not accept it. If you're married, presumably you'd name your spouse first. If you're not married, then you think who in your spheres of influence is good with their money and a person of integrity who will take care of your money. It doesn't have to be a family member. It could be a church member. It could be a neighbor. It could be one of your book clubs. It could be a sorority sister, fraternity brother. So think beyond just, well, my family, I'm not sure I want to name anybody in my family. You don't have to. You don't have to. So, and this is not giving someone a blessing. It's a lot of work. If any of y'all, I've talked to several of you today where you've handled your parents' finances, it's a lot of work. So naming someone in your power of attorney, talk to them and see if they're willing. Because you say, my son Johnny will do it. Well, maybe he will, maybe he won't. You need to talk to him. Okay, next slide, please. Healthcare surrogate. Healthcare decisions. Many of my clients will name family members who have a medical background. That's great, but it's not necessary. It's basically all of us who go to the hospital have to listen to what our doctors tell us and pray about it and then make our best decisions. So you want to name somebody who's going to listen to the doctors, hopefully is a Christian, and then we'll make the best decision. Again, it's the same thing as power of attorney. It doesn't have to be your rotten son Joey. It could be your church buddy. It could be your neighbor. You know, you don't have to name a family member if that's not an appropriate person to name. Many times it is. Unlike the durable power of attorney, the document we talked before that, we want to name one at a time so banks will accept it. So we would put one person, and if they can't or won't, we put another person if they can't or won't. I like 3. Healthcare surrogates, we can go or. So whoever shows up at the hospital first can help make decisions. That would be my preference, or on healthcare surrogates. We good on questions so far? Okay, next slide, please. This is my favorite estate planning. Okay, wait a minute, got some questions back here. Yes, ma'am. I will try to do better. Is that better? No. I want you to hear what I have to say because it's going to help you. Okay, I will try to keep it on my chin then. Okay, I can do this. All right, anything else? Good. Favorite cartoon in the world? Mama and Papa sitting in the recliner. Papa says, just so you know, because I'm reading it in case you can't read it from back there. He says, I never want to live in a vegetative state dependent on some machine. He says, if that ever happens, just unplug me, okay? Mama says, okay. Next slide. She gets up, unplugs the TV. I love that cartoon. I just love it. I got other ones later, and they're corny. This is the best one. You got the best for last. I mean, the best at first. Obviously, we're talking about living will, unplugging, which is the vernacular, the street vernacular. I'm sure our medical folks here would think, oh, no, please don't say that. Go to the next slide, please. Living will. Again, we already talked about it is not a DNR. That's a do not resuscitate. This is in my office, and I'm sure most estate planning attorneys, I spend more time talking with the clients on this than any other. So I want you to know what it does and does not do. This is respiration, hydration, nutrition. This has nothing to do with comfort care. The big issue about this living will, you're not naming your daughter Barbara to make her best guess or best decision whether keep you plugged in or unplugged. You're naming your daughter Barbara to enforce the wishes you make at that conference table when you're not in crisis. So that's the big, big, big distinction. And also here's a point of practice that I've learned. And I don't mean to be offensive to any medical professionals or folks who work for hospitals, but I'm seeing a pattern since the Terry Schiavo situation. And you may recall that was the lady who had the severe brain injury And there was a big media circus on whether she was in persistent vegetative state, which is one of the 3 scenarios. And the back and forth on that, we had hoped when the media circus died down that we would have a better law in place for living will. But because it is a political hot potato, we have the same silly law that we had then. What I'm seeing with hospitals and medical facilities, they have become more aggressive with living wills. Meaning, if you sign, Charlie, a living will, and you give it to the hospital when he checks in, they've got a document that's enforceable right then. And so when we have a family member in end of life, many times, almost always, we want to pray about it. We want to gather. We want people to come in, family members from out of town. We want to say goodbye. And the hospital, on 2 different occasions for my clients, has had the living will document, and they've disconnected with the family saying that, wait, we got to get family in town. So my recommendation to you all is if you do sign a living will, and I recommend you do because I think it's a good thing to have, if you sign a living will, when we check into the hospital, here's our photo ID, here's our insurance card. Do you have a living will? Yes. Can we have a copy? Sure, but I don't have it with me. Do not give it to the doctors or the hospital until you as a family are ready to institute those wishes. Because I've had 2 different crying calls from adult children of clients saying, they're not waiting. So, point of practice. Okay, next slide, please. These are the 3 medical conditions that a living will applies to. I have a lawyer brain. The definitions to me do not make a lot of sense. I'm going to give you all 3 definitions just so that you have them because they may make sense to you. If you go to the next slide, I'm going bottom up. Persistent vegetative state. That's kind of easy for me to wrap my head around. That's the brain injury, the severe brain coma, the things we're not coming back from. The patient is plugged in, and the likelihood, I know God can always perform a miracle. I'm not taking that off the table. But the medical probability of improving or getting better from the medical perspective is no. So if you decide that you were in, that's the legal definition, and did not want life support continued, you'd initial persistent vegetative state. And by the way, husbands and wives, yours don't have to match. If mama feels strongly about it, but daddy doesn't, that's fine. They don't have to match. This is very, very personal. And please don't let your estate plan attorney talk you into this. This needs to be what you want. Next, please. Terminal condition, there's the definition. If you compare the definition of terminal condition and end-stage condition, which is the next one, they sound just alike to me. I'll tell you what my medical clients say, and this has helped me. Terminal condition would be like cancer, where everything that could have been done has been done, and cancer has tipped over to treatable to terminal, and the machines are keeping the person alive. If you go to the next slide, the end-stage condition, my medical clients tell me that's like Lou Gehrig's, Parkinson's, where there wasn't a cure, but it's at the very last of a stage disease. It doesn't matter what I think, it's what each of you think. If you do not want life support continued, you'd initial on the living will, which basically says, let me go. Okay, go ahead. So, I'd mentioned this before. These are the 3 things that a living will applies to. Comfort care is still provided. Go to the next slide. I've had a lot of clients ask me, well, I don't want to be dying of thirst. I don't want to be dying of hunger. So a lot of times we'll add this provision that only if there's clear evidence that adding the nutrition or hydration will cause harm. So I wanted y'all to have this. And by the way, Charlie's got the PowerPoint if you want it emailed to you after this. So you'll have this information. That's fine. So you can take it to your estate plan attorney. You can go to the next one. Okay. Obviously, I'm a Christian. Our office is faith-based, and I routinely offer it's pretty easy to find out if the client or the prospective client is a Christian or not, how they carry themselves, how they speak, and they usually will notice the humongous cross in my lobby. That's a good indicator. So if you decide you would like to incorporate Christ in this documents, we've got specific language we can drop into the intro paragraph of the last will and testament, and there's no formal reading of a will anymore, but a lot of people will see the will after you're gone. And this we drop into the living will, this type of language. Also, you can craft your own. If you get an estate plan attorney who is flexible, you can craft your own language that glorifies God within the documents. So, next slide. Okay, Papa and Mama talking. He says, I keep having this nightmare that we don't spend the money and time and the kids inherit it all. Okay, partially not scriptural. We all know we need to leave an inheritance for our children and our grandchildren. So I'm not saying disinherit kids or grandkids. But all of us have worked really hard during our lives, and so we want to make sure that we are a blessing to those that glorify God, and that we want to be a blessing to them. So go to the next slide, please. Last will and testament. This is the document, the roadmap to the probate court, who gets your assets and who's in charge. It gives you the ability to direct specific things. It gives you the ability to direct your whole basket of stuff. So it's completely what you want. A lot of times, if we have one of our children is doing real well with their career and they're not going to need the finances, then we may want to do for the one that's not doing quite so well. If we have, God forbid, a child who has an addiction, we may not want to give them inheritance. We may want to funnel that money to a different type of investment, Keith Haskell, different type of investment to benefit that child, the addicted child, during their life, rather than putting money in their hands that'll just flit away. Same thing with a spender child. You may not want to give a spender child or a spender sister or a spender family member a big inheritance. You may want to put some strings on it. Keith can do it, I can do it. We'll get into that later. Next slide, please. Okay, I mentioned this at the beginning. All of y'all have a will, whether you went to see an estate plan attorney or not. The state of Florida will basically says your spouse gets part, your children get part. That may not be what you want. It also says your spouse is in charge, or we used to call them executors. It's called personal representative now. That you may not want your spouse to handle it just because of age or infirmity. You may want your daughter to handle it. You may want your second cousin to handle it. Florida law requires your executor is either a family member by blood or marriage, or they're a Floridian. So if you want to name your fraternity brother in Illinois, unless he's related to you by blood or marriage, you can't name him as your executor or personal representative. Okay, next slide. Probate avoidance. This is my favorite subject. I make a lot of money on probate. Completely unnecessary to do probate. Completely. Just with a little bit of planning, you can avoid it. Remember, that's the court process of getting the assets out of a person's name into the person they want if they had a will, or who the state says if they don't have a will. You can avoid probate by properly designating beneficiaries on your assets that we can name a beneficiary. Let me give you some examples. Life insurance, IRAs, 401ks, CDs, money market accounts, most brokerage accounts. You can name beneficiary designations. They don't go through the probate process. They don't go to court. You got contract law up here. You got probate law down here. So if the contract on the money market account says, name a beneficiary, then it never gets to the probate court, which is awesome. Another popular method to avoid probate is joint titling. You've got a bank account. Chase will not allow you to name a beneficiary on that bank account. This is kind of a disclaimer, a little bit of a warning. You want to put your oldest son on there. Okay, I'd say do that carefully. If oldest son has a lawsuit coming against it, him, that asset may be subject to the lawsuit. There's some additional information on that, but I'm hitting the broad strokes here. If oldest son is a spender, he may grab it and go to Las Vegas. If oldest son has an addiction, probably the one I see most often is oldest son starts dating a bad girl. So you have to have a really good, solid family before I would recommend naming one of your children jointly on your bank account, or your sister, or your cousin. It's all the same thought process. It's great because banks are last man standing owns it. So if you pass away, whoever you've named jointly will own that account, no probate. If they pass away, you still own it. So do joint titling carefully. Right of survivorship. Keith and I were talking about it earlier because right of survivorship is, again, last man standing owns it. What we use this most effectively is a Ladybird deed. And remember Ladybird Johnson and President Johnson had some scary, smart lawyers, and they came up with this. It's nothing more than a legal maneuver, but it's legal in Florida now. It has been for about 15 years. And there are two types of ladybirds, and that may be why this neighbor said do a ladybird and this neighbor says don't do a ladybird, because there are two types. I'm going to go through both. Ladybird in general is where you keep the ownership of your house in your name, and the inheritance right we're peeling off of you and giving it to somebody. So it's in the deed. So, Marcia, I'm picking on you. You name yourself as the life estate on your house, and the remainder, which is the inheritance right, to me. So when Marcia passes, if she passes before I do, then I record her death certificate and the house goes to me. No probate. It's a marvelous invention. Now, the two types. One is where Marcia keeps all the rights. That's called the enhanced Ladybird deed. The only right I'm peeling off of her is the inheritance rights. It's a great thing because if she wants to refinance it, if she wants to sell it, if she wants to gift it, if she wants to burn it down, it's hers. I have no present day rights in it if I am the remainder interest. The other one is called a simple Ladybird, where I'm removing all the rights from Marcia except the right to live in the house and pay the taxes. And in that case, if I am the remainder interest, she wants to sell it, she's got to get my agreement. She wants to refinance it, she's got to get my agreement. If she wants to give it, she's got to get my agreement because I'm the holder of all those rights. This second Ladybird, called the Simple Ladybird, it is a great tool if we're trying to plan for Medicaid, going to a nursing home and having the state of Florida government benefits paying for Medicaid. It's a great tool. It's not so good a tool if you want to keep control of your house. So depending on what your circumstances are, I rarely do the Simple Ladybird, except when we have a client who's probably going to need nursing home fairly soon. So and I will tell you, here's another practice point that I've seen because we've been doing Ladybirds now for 15 years. Title companies don't like them. They don't understand them. Banks don't like them. They don't understand them. And so what we're seeing consistently is if I've put a client and their home in a Ladybird deed, this is the enhanced one where Marcia's kept all the rights and the remainder goes to me. The title company is demanding if Marcia wants to refinance her house that I have to join in. Even though I have no present day interest, that's simply because they don't understand them. And I've had this argument with their underwriters many, many, many times. You can't win it. So what we do, we transfer it out of Ladybird, you refinance, and we transfer it back. So, but that's the one issue. I'm always asking clients before we do a Ladybird 2 questions. Do you have minor children? Because you can't do it if you have minor children. And are you thinking of selling or refinancing soon? And if no minor children, no refinance, no selling, then yeah, let's do a Ladybird. It's great probate avoidance. Okay, the elephant in the living room is the trust. You'll hear revocable living trust, You'll hear living trust. You'll hear revocable trust. They're all the same thing. I don't know why all the confusion. This is like, you can go to the next slide, Charlie. These are the benefits of a trust, and let me give you some ideas of when I would recommend a trust, because the simple estate plan is fairly reasonably priced. We're going up the $5,000 range when we're talking about the trust package. So I'm not going to recommend that unless you have some of the compelling reasons to justify the legal cost. Some of those compelling reasons is, do you have someone you are supporting, someone with special needs, someone who's elderly, that you are financially taking care of them? You put the assets in the trust, and then it takes care of you during your life, and if you become incapacitated or die, it can take care of that person. Do you have children from a previous marriage? A trust ensures that your children from a previous marriage will inherit. Whereas if you just have a will, husband gets it, spouse gets it, and then he or she may provide for your children or they may not. The other reason for a trust is your asset level. If your asset level's subject to probate exceeds $500,000, then I'm going to recommend a trust. We're going back subject to probate. If we've done a Ladybird deed on your house, that's not subject to probate. If all your investments are beneficiary designation, that's not subject to probate. If your life insurance has a beneficiary, not subject to probate. Your other assets are jointly titled, not subject to probate. I'm going to say, no, you don't need a trust. I talk all kinds of people out of a trust when they come to my office because they've been watching Susie Orman on TV, who says everybody needs a trust. No, it depends on what your assets are. It depends on your family dynamics. Next slide, please. There's our basket. Yeah, see if the stuff in the basket falls in. Sometimes this works, sometimes it doesn't. Hit enter. Okay. There's your money. There's your RV. There's all your stuff going into your trust. We don't put our cars in our trust. So we're putting our assets in the basket. The basket virtually takes the place of the probate court. You do not have to go to probate if you properly funded your basket. You can go to the next slide. Okay, new laws. And I'm just going to touch on these because we've had some sizable changes since 2011 that may affect what you have. Or if you go see an estate plan attorney, you can ask the really good questions. 2011, we had a huge law change to durable power of attorney. Probably the biggest change to that used to be we could sign a durable power of attorney, but it didn't come into effect until the doctor said we're incapacitated. We can't do that anymore. That used to be called a springing power of attorney. It springs into action when you've lost capacity. You can't do that. When you sign it now, it's valid. It's giving someone authority over your finances, so don't give them the document. You can tell them where it is, but don't give them the document. Just tell them where it is so they can get it if you lose capacity. Another big change to durable power of attorney, banks will rarely now accept a power of attorney prior to 2012, simply because so much in the document has changed. So if you've got an old power of attorney older than 2012, go see your estate plan attorney and get it updated. Just a reminder, we want one agent named. That's who you've appointed. And if they can't or won't, then we want a second one. And if they can't or won't, I like a third one, but we don't always get a third one. Okay, questions so far? We're good? Okay, healthcare surrogate designation. In 2015, we had a big law change on this. I like every part of the new law except one. By the way, with that 2015 law change, those of you who have grandchildren or minor children, you can now set up a healthcare surrogate designation for your minor child or your minor grandchild. You couldn't used to do that. You remember those of us who'd leave the note for the babysitter before we head out the door? You have my authority to take the kids to the hospital if they need it. Yeah, it didn't do any good. That you can do a healthcare surrogate now for your minor children. So tell your kids if you've got grandkids. 2015, the one part of the law change I did not like was now for your surrogate to step in for your behalf. Remember, this is part of the incapacity documents, the advance directives. If your surrogate is to step in, two things have to happen. The doctor has to say you're incapacitated. Well, yeah, we don't want them in our healthcare decisions unless we're incapacitated, but the doctor also has to put it in writing. And because doctors get sued all the time by lawyers, that they're very, very slow to put it in writing. So we add a provision in our healthcare surrogate that waive the determination, the writing determination. So tell your estate plan attorney, I want to waive that provision. So next slide, please. Oh, okay, a couple of things, clean up. I was asked about reverse mortgage by a very dear friends of mine 4 years ago. And I asked Keith, does he agree? And we're on the same page. Unless you're eating cat food, please don't do a reverse mortgage. They are not for your benefit. The fees up front are massive. The fees at the end are massive. And there'll be no house equity left over at the end of it. The better method, if finances are tight and all you've got is your house, refinance if your credit will allow it. If it won't allow it, downsize. Do not do a reverse mortgage if you could possibly, because it looks very enticing. For those of you who are not familiar, reverse mortgages, instead of you paying a mortgage, it's a loan, instead of you paying a mortgage, they're paying you money. They're paying your mortgage loan amount every month, and sometimes even some cash coming in. Sounds really good, but it's eating away the equity in your house, so there'll be nothing left. You have the right to live there all during your life, and I would like to point out 9 out of 10 of us will need to go to some facility during our fragile years. So when I talk to clients constantly, what's your plan towards the end? Do you have a plan in place? Would you consider discussing with me a plan? Oh, I'm going to stay at home. That's not a plan. That's not a plan. My husband and I, we had really a lot of challenge with my mom towards her last 8 years because she would not plan and would not allow us to assist in any way. So my husband and I decided we're not doing that to our children. So when he can no longer work at his wood shop, we're moving into an independent living that has transitional care, to assisted living, to nursing home, because it'll be all in one place and the kids don't have to move us. And we pick it. Our kids don't pick it. My mom hated the places we picked for her. So please seriously consider, and I know I'll get a lot of you, I'm going to stay at home. Okay. 9 out of 10 of us won't stay at home. So something to consider. Any questions? I know we're ending on a happier note. Any questions? Let's do this. Wait a minute.
From our online audience, Donna Elliott asked, durable power of attorney needs to be written in or after 2011 or 2012? Which year?
Hi, Donna. I remember you. I like you. The law changed in 2011. Everything hit the fan on it in 2012. So banks, if you walk into a bank with a 2011 power of attorney, chances are very, very good it's old law, unless you had an extremely progressive attorney who jumped on that law when it passed mid-year, changed all their documents, and signed it. My recommendation is if your power of attorney is older than 2012, get a new one. And you can't amend them. You got to get a new one. Okay. Thank you for doing that. And thank you, Donna. Anything else? Wow, I did that good a job. Yeah, it's kind of like drinking from a fire hose. Said at the beginning, not selling the estate plan. Keith and I, both of our cards are in the back. If the best way to reach me is my email. Charlie, can you get to the end? Because I got a bird flapping. Keep going. Is it gone? Yeah. My email is Dove Attorney for the Holy Spirit Dove. So if you have a question, email me. I am. You can go all the way to the end now. Email me. I'm kind of a challenge getting on the phone, but email me and I'm happy to respond whatever you've got. So, all right. Thank y'all.
Well, good morning, everybody. Okay, my name is Keith Haskell, if you don't know me. Okay, and I've been to this church about 40 years. I think it is about 40 years now. So, the lights turned out, and I'm out. If I go to sleep, just kick me or something, will you? So, there is so much, okay, to do with taxes as far as estate and tax or estate and gift tax. Okay, there is tons of it. This is actually my second PowerPoint that I did, because after I did my first one, I said, they're going to be drinking out of a fire hose. Okay, so I needed to get down to basics on this particular thing. By the way, Lynn and I go back and forth with clients and everything. So one thing I wanted to tell you a little story, though, because I do send, a number of clients to her. And she is the only attorney that I know of, okay, that when she gets through with the client, they call me on their cell phone, okay? They don't even get to the house. They call me on the cell phone and thank me, okay, for sending me to Lynn. Okay, she is that sharp, and you've already heard her up here and everything, so she's just a beautiful lady. Let's just put it that way, okay? So, let's crank it up, okay? So I know this is hard to see, but this is one of the ones that I did on my own. And basically what we're saying there is, let me back up a little bit, okay? Because somebody just asked me a question a little while ago. The first person that you need to see is Lynn, not me, okay? Because of the fact that everything that she's going to do is going to try to protect you, okay, the best she possibly can. All right, so it's liable to be a number of years before you need me. You should probably see me at least once, though, because of basis, because of transfer of assets. There is so much, that we need to talk about just to protect your assets, okay, and things that you're doing. So anyway, this right here is basically saying what happens after you're gone. Okay? Yeah, exactly. Exactly, because IRS definitely wants to get in your pocket. Okay, I can guarantee you that. So what this is telling you right here is how many people knew that they had at least 3 tax returns to do in the year of death. Anybody out there? Didn't think? Yeah. Lynn does. Okay, at least 3. Okay, the first one up there is a 1040. So what I try to explain to people is this. Okay, that's your regular income tax return for individuals, and joint tenants. Let's say, God forbid, okay, that you pass away March 31st of a particular year. All right. So what happens is you still have to file a 1040, the individual or joint tax return. Okay, you still have to do it. But what you're going to do is you're going to consider your income from January 1st to March 31st. Okay, then what happens? No, Iras doesn't forget it. Okay, the next one is the Form 1041, and that's called a fiduciary or estate tax return. Here's what gets a little confusing to people too as well, is when we're talking about estate tax returns, there's actually 2 estate tax returns. One of them has to do with the taxes on the income, okay, that you get from the point of your death to the time that you actually disperse those funds to your beneficiary. So IRS wants to know, well, what came in during that period of time? Because it could take a whole year to get it done. Hopefully it will not, okay? But it can. So what you have to be concerned about is that second one. And what it's saying basically, I'll read it to you. It says from the date of death, income, in other words, plus income, plus some IRDs. What's IRD stand for? Income in respect of a decedent. Okay, big word. You don't have to worry about it. I do. Okay, and then you're able to make some deductions on it, and then it goes to the date that you distribute those assets to the beneficiary. Okay, so everybody understand that? That's income that we're talking about. Interest usually, dividends, can be installment sale that you get, and so on and so forth. So what Iras is concerned about is that we're talking about income from the date of death till the time that you distribute those to the beneficiary. Then there's a third one, okay, and it's called a 706 form. That's really, and technically, your estate tax return. What does that do? Okay, that is really a value-added tax, is what it boils down to. IRS wants to know on the date of death how much in assets did you acquire during your whole life. Okay, because there is technically a value tax on that. So they want to know, and you have to bring everything in. Okay, so what it's basically saying there, it's this value-added tax. By the way, the guy that typed this up, okay, the exclusion, okay, is 11,700,000. Okay, today. What I just found out recently, okay, is that next year, okay, 2022, it's going to be cut in half. Yes, it's going to be cut in half. Okay, it's 5,850,000. There is also what they call a sunset law that I believe that they're going to bring it all the way down to $1 million. And that could happen January 1st of 2026. And when they do that, there's probably a lot of people in this room are going to be caught with that. I wish there was some with 11.7, but there's not too many of those. But that's what they're trying to do. Obviously, they're spending money like crazy up there. Okay, and they're looking for every dime that they can get. So it could drop down to that amount. So that 11,700,000 is an exclusion, okay, for all your assets. House, second house, vacation homes, insurance, all this kind of stuff, everything, including some gifts, okay, that you've done within, it has lifetime down there too as well that says all property owned or controlled, okay, or controlled, which means that you could have a joint ownership with somebody, okay, and, it technically goes back into your estate as far as the value of that particular item. Okay, so there's a number of things. So watch out for the control part of it. Okay, so there's property owned and controlled by the decedent at their death. That also includes the IRDs, which is the income in respect of a decedent. It comes back to this particular tax return. Okay, also includes lifetime taxable gifts, where you actually put it on, you actually put it on a 709 form, which is a gift tax return, okay, where you've given somebody more than $15,000 per year. It's another thing you need to write down. You can give gifts up to $15,000 to any one person. So, as an example of that, let's say husband and wife want to give their child, okay, some money because they're, an adult buying a new home. The husband can give $15,000 to the daughter. The wife can give $15,000. Okay, that's $30,000. Suppose they want to give $100,000. Well, they can do that. Okay, but the other $70,000 is going to go against that $11,700,000. Okay, and it's going to go on a 709 form. Okay. Filing deadline for that 706 form, by the way, is 9 months from the date of death. So if they die March 31st, December 31st is the due date of that return. Okay, you can get an extension on that though, normally. Okay, must file a 706 to elect portability of spouse's unused exclusion amount to the surviving spouse. This is something relatively new. It's probably been in existence 5 to 10 years. But let's say right now that I always kick off the husband, by the way. So, so let's say the husband passes away, all right? And let's say he doesn't use all of his $11,700,000. Can he transfer part of that to his wife? And the answer to that is yes. But you must file a 706 form to do that, okay, which is the estate tax return form, okay? But you can transfer that over. Now, the interesting question is this, okay? Let's say that it happens this year, all right, and they're able to transfer, let's say, $10 million over. What happens next year when they go down half? Good question, okay? Okay, this is the 1041 form. That's the fiduciary estate tax return form that has to do with the income between the date of death and the date that you actually transfer those assets to the beneficiaries. Behind this is a bunch of K1s. You've probably seen some K1s if you are in a partnership or something like that. You'd wind up with those. In other words, each beneficiary that gets distributed some assets, okay, will get a K1, which will tell them what their percentage of the income is for that period of time. Okay, so I just threw that up there for you. Not that you really care, probably, but that's all right. Go to the next one. So, okay, here's the thing right down here that I'm looking at, okay, is the estate gift tax. Some of these things are going to be a lot better, by the way. I just tried to put these in there because I thought they were most important because they relate directly to us right now. Okay, the exclusion for estate and gift tax, I told you, is $11,700,000. Okay, and the gift, okay, the annual exclusion gift, okay, is the $15,000, which is what I told you. Okay. But here is something else interesting. Let me get to see mine here too. Okay, it says a gift, okay, to a non-citizen spouse. Some people don't think about, okay, is if you are now a non-citizen spouse, what do you think your estate and gift tax exclusion is? 0. Exactly right. Okay, it's 0. So what do you do there? You make sure that you give your wife at least, what is that, $159,000? $159,000. Just gift it over, to her. Okay, and there won't be any problem doing that, everything. So, but you need to be concerned about that. Oh yeah, by the way, do you know what the tax rate is? Let's say that you do go over the 11.7 or 58, what is it, 5,850,000 next year. Okay, what do you think the tax on estate tax is? Anybody? How about 40%? It's wicked. It's wicked. That's why you need to see that lady that's sitting down over there, okay? Because of the fact that hopefully she can get you out of a lot of this stuff. You need to see her first, though, okay, and then see me second. And then Lynn and I will get together, okay? So what are our, the income in respect of a decedent? And what that is, like I said, is a decedent must have, okay, what I'm showing there is examples, I'm sorry. So what I'm showing is an example. What happens if you have a sale going on and all of a sudden that person dies? Is that income in respect of a decedent, or does it transfer directly to the beneficiary? Okay, this is what it's telling you there is the decedent must have a contract for sale. In other words, he's already started the sale with this particular person. Then he dies, is what I'm saying, okay? So he must have a contract for sale. The property must have been in deliverable condition. What does that mean? Well, let's say you had a bunch of trees on this raw land, okay, and the buyer wants you to take those trees down. And you didn't do that before death. Does that make it an IRD? Income in respect of seed? No, it doesn't. No, it doesn't. So you don't have to be concerned about that, okay, as far as the 1041 form, that fiduciary thing having to do with income. What happens to it? It goes directly to the beneficiary then. The beneficiary is the wife. She can handle it from that point. Yes, hello. Okay. Flip it over if you would. Okay, how about an installment sale agreement? Basically the same thing. Okay, basically it says that the recipient, in this particular case, the recipient, meaning the beneficiary, steps in the same shoes as the decedent. Okay, so what? In other words, it's already been consummated. Okay, then he dies. Okay, the one who receives this asset after death, okay, receives it exactly like it is. Okay, same principal and interest, length of loan, and so on and so forth. It remains the same. Okay, Charlie? U.S. savings bonds. Whew. I had one of these. Okay, so this year as a client, I have a client that had a dad. Dad passed away. Dad was a good saver, especially during the world wars and all that. And so he bought U.S. savings bonds all over the place, okay? And he had about $80,000, $90,000 worth of U.S. savings bonds. Now, what happens with those? Okay? He left them to his daughter. Now, one of the stipulations that you had with the earlier U.S. savings bonds is that you could take the interest on your individual tax return if you wanted to. And you could do it every single year. So you just took it because you were in a lower tax bracket or so forth. But what happened is that if you don't do that, then all flows, okay, to the recipient. One of the problems is that we didn't have the deceased tax return. Had no idea whether he declared that. So guess what happens? Okay, yeah. So what happens, I had to put the whole thing on her tax return this year, okay, because I couldn't prove it, and if I can't prove it, it's not going on a tax return. Simple as that, okay? I don't play those silly games. By the way, I've been in this business more than I like to tell you, okay? And as far as I know, okay, I've had 0 audits for 10, 20 years, whatever it is, okay? I don't even know where the IRS office is anymore. So, but, that's not to say that I'm absolutely perfect. I only know one that is perfect, okay, and he's up there. So, but I guess the IRS trusts my tax return because I know I don't play silly games. So, anyway, on this particular one here, so I had to put it on there. And, but, if I say anything up here to you, okay, remember this one thing, communication. It is so vital when it has to do with estate and gift taxes, okay? You need to communicate to Lynn, you need to communicate to me, and then, okay, we more than likely are going to ask you whether you have any assets very similar to this. Because if you do, I'm going to say, if you got it as a gift, okay, I want you to go back to that particular person that gave you the gift, and I want you to find out what their basis is. That's on the second set of slides that I don't have, but it's so important, I want to tell you that right now, okay? That because you have to know what the basis is. In this particular case I just told you, I didn't know her basis because I didn't know whether he declared the interest or not. So I just had to say, basis is 0, you got to pay the taxes on the whole thing. But if I knew the dad or I knew her, and said, go back to your dad, because I know he was alive, because I've had her for, some clients I've had for 40 years. Okay, and I'm only 39. You figure that one out. So, okay. But, I knew, I didn't know her dad personally, but I knew he was alive because she would tell me all the time when I'd meet her, this and, you get all kinds of interesting stories. So, but, I could have said to her, you got bonds, or he has bonds he's going to give to you. Go back to him and find out, okay, what he did on his tax return. And if you can convince him, get a copy of the front page of his tax return for me for at least 3 years. And let me see that that's exactly what he's done. If I can see that, I would assume then that he's done it in prior years as well. Okay, and then she'd have a basis on all that. So, in fact, she'd probably pay very little tax, which I think the tax on that particular stuff was like, what was it, $23,000 or something like that. So, yeah, I mean, could have saved her a bunch of money. Could have saved her a bunch of money. Next one. Same thing there. Okay, accrued interest. What we're talking about there is your CDs and time deposits. Okay, interest accrued up to the date of death. Okay, so what I usually get a lot of times is I'll get their brokerage account statements and all that, and I'll bring that up, okay, to the point of death. I'll find out what their interest is, their dividends, and so on and so forth. That'll go on their 1040, their individual tax return. Okay, I take the other part of it, and it goes on to 1041, which is the fiduciary return that tells me, that's where it went, up to the point where they actually distributed the CDs or the other amounts. So, no, I don't sit on my thumbs. It's difficult. Okay. Frequently overlooked. Okay. Okay, don't assume assets. Okay, yeah. Don't assume estate was not taxable. You'd be surprised what people have. I'd probably be shocked, and some of you, okay, what you've got right now. So that's why you need to go see Lynn. Okay, and then she'll send you to me probably. But we need to find out about that. All we're here for, and she's right. Okay, you're not dollar signs to me. Okay, it says in the Word, okay, that we're here for a purpose, and that purpose is to serve you, to love you, and to serve you, and that's why we're here. I could have retired a long time ago, folks, but God keeps on reminding me of that. Next, that was the last one. Okay, opportunity, pre-mortem. Actually before death, converting traditional IRAs to Roth accounts, depending on what your tax structure is. It all depends on what your tax structure is, okay? I have, like last year, I did a client, and let me drop back a minute, just for compliance reasons, because I wear too many hats. Okay, I was told, that I'm an EA and I'm a CFP, Certified Financial Planner, okay? The EA stands for Enrolled Agent to Practice Before Internal Revenue Service. So there's only 3 of us normally that can actually represent you in front of IRS and go to tax court and so forth. So I don't go to tax court, is that her? Okay, but so I'm doing this as far as doing the seminar as an EA, Enrolled Agent to Practice Before Internal Revenue Service, because it deals with tax, okay? I'm not standing up here as a CFP, although it was advertised that way. That would relieve me of the compliance session, okay? So anyway, that depends on whether you want to do that, whether you want to convert your IRAs to Roths. I've got a few slides in here that, if it applies to you, can make you thousands of dollars. I'll bet you that'll wake you up, won't it? Okay, so, and post-mortem, some other stuff. No, that's all right, Charlie, go on. Okay, there's the decedent's taxable estate. That was 2020, as you see there, okay, is the $11,580,000. This year, it's $11 $1,000,007. Okay, tax on the rights to transfer the assets. Okay, we already went through that. Double taxation. Is there double taxation? Well, there could be. Okay, because what happens is those income in respect of a decedent can go on that 1041, or actually the 706, which is the big estate tax return, where you actually pay for the value of that. Okay, everything goes on there. Okay, everything goes on there. So you could be taxed on the income of respect of a decedent. In other words, the money that you would have gotten if you didn't die. Okay, so they want that on the estate tax return form. Okay, and if it's taxable, you're going to pay taxes on it. So, but how about the person that received that money? Okay, they're going to pay taxes on that, probably on their 1040 form, which is the individual and joint tax return. So they get to deduct the estate taxes that were paid on the 706 form. Okay, so we'll go through that. I think I've got a slide on here too, but that's what they're talking about, estate tax deduction. So you better know somebody what they're doing on this thing. It is, I mean, I'm probably, throwing water out of a fire hose right now, so, but I'm sorry about that. That's the only thing I can do. I tried to get it down as low as I could, but, it is so much of this stuff. Okay, go on, Charlie, to the next one. Okay, here's a little bit what Lynn was talking about, though. Okay, is inherited IRAs. Okay, and I know she skipped over that. Thank you. Okay, what this is basically talking about is if you've got an inherited IRA, example, okay, is you have a dad, 3 sons. Okay, he dies. He's got an IRA. It transfers over to the sons. Okay, those are called inherited IRAs. But what I tell you before about IRS, they want it now, or even sooner than now if they could get it. Okay, and that's what this is all about here, is distributions. What happens, okay, when you receive an inherited IRA? There's 3 different methods, and it depends on which category you fall in. Okay, there's usually the decedent's surviving spouse. What does stretched mean, by the way? Stretch means normally that you have to take out of the inherited IRA over a period of time. That period of time, when you have a stretch, means the lifespan of the person that's receiving it. So if you have a younger wife, that's really good. But what happens to her is she falls into the second category, because it says it up there, right down at the bottom, where it says individuals less than 10 years younger. That means you've got an older wife. Okay, so what does the mortality table do? It shrinks it down because she's older. You can almost look behind some of these laws and see exactly what they're doing, okay, with that particular situation. So they're saying, okay, we know she's going to live a whole lot less than a wife that's 10 years younger. Okay, so we're going to give her a stretch IRA. Give her this stretch rule. Okay, but then you've got over here, the designated, which is a non-spouse, which is all the children. Okay, certain see-through trust, individuals 10 or more years, okay, younger. All right, so they only get a 10-year rule, which means that, again, they have to take the money out of the inherited IRA that they received over a 10-year period. Now, can they do it every year? Or can they wait until December 31st of the 10th year? Yes, they can. But boy, if it's a big IRA, you might not want to do that. So that, again, is something we need to look at. Okay, and say, okay, well, I recommend thus and so. It's your IRA, folks. Okay, I'm going to recommend, it's going to be your decision on what to do. And then you've got the 5-year rule, which is, they've given it to, charities and all that kind of stuff. So another complicated situation here when you receive an inherited IRA. Okay, Charlie. Okay. This is a nasty one. Okay, because you got a minor child. Okay, who moved from an eligible designated category to a designated. Okay, they're 18 years old, right? Okay, so at 18 years old, okay, they get on that particular one what a stretch. Okay, because they're younger than 18. Go to the next slide and see what happens. Okay, got Ava. Was 14 years old in July 2021. When she inherits her mom's IRA, her mom had not reached the RBD, which that is, reached the birth date to be required to take a required minimum distribution. That's all that means. Okay? Is Ava able to use the stretch rule for her lifetime? The key word right there is lifetime. You would think that she would be under normal circumstances, but they're not. Why? Because IRS wants all the money they can get. Flip it over, if you would, sir. There it is. The answer is no. Security Act in 2021 rule, okay, has changed it. She can have that stretch for age 14 through 17, but when she reaches her 18th birthday, she falls into the 10-year category. So from 14 to 17, she could have had 60 years to stretch that IRA out. But then they just changed it, said, oh no, we're giving you way too much time. You can't have all that money for that long. You know, so we're going to change it. When you hit 18, we're going to make you give it to us over a 10-year period. So you just went from 60 years down to 10. Okay, next. Okay. Removal of age limit. Oh, yeah, okay. When you reached required minimum distributions year, which prior to this year was 70 and a half. Okay, when you reached 70 and a half, you could not contribute to your IRA, period. Okay, what this rule has changed now is that you can, contribute to an IRA at any age now. But watch out. Okay, turn it. Okay, we got Emily. Okay, she's 73 years old. Okay, has $10,200 at her part-time job. Her W-2, that's what her W-2 shows. Okay, she contributes $3,000 to her IRA and wants to adjust her taxes for the deduction. In other words, she wants to reduce that $10,200 by the $3,000 because she made a contribute, and she contributed to an IRA, which most people know that. Okay, but what happens in 2021? Okay, she received a 1099-R, which tells you that she contributed $4,000, okay, into, what should I say, actually to her church, I should say, okay. Now, this was the year after. What do you think IRS is going to do with this one? This is brand new. Okay, this is brand new. So what happens on her 2021 tax return? Flip it. Okay, now she's required to go back, okay, and pull that $3,000 IRA that she got a deduction for in 2020. By 2021, they want you to reduce that IRA contribution or deduction, actually, okay, by the amount that she received for a QCD. Now, what is a QCD? Qualified Charitable Distribution. Okay, we're going to get into that in a second. Okay, so all of a sudden, instead of that $4,000 that she thought she didn't have to pay any taxes on, now she's going to have to pay taxes on 3 of that because you had to go back and pick up the deduction that you got in the prior year. Isn't this fun? Okay, so, and that's, that's what happens. Okay, everybody with me? Okay. Okay, next. Okay, all right. All right. Backdoor IRA. Boy, does that sound illegal? But that's the true name of it, okay? And basically, this is for people, as you can see, that make over $208,000 as married filing jointly, or $140,000 single, okay? And what they're saying that you can do, because those are the phase-out periods on whether you can contribute to an IRA, all right? So what they're saying is that you can no longer contribute to a Roth or an IRA. All right? So how do you do that? Okay, if you really wanted to, but you're knocked out because of the amount of money that you're making, you can actually contribute, okay, to a non-deductible IRA. It has no phase-outs on it. So you contribute to a non-deductible IRA, and the next day, or the same day for that matter, okay, you convert it to a Roth. Okay? Now, what's the difference? Anybody? Well, they're both, okay, technically after-tax dollars. In other words, you're using after-tax dollars. Even because a non-deductible IRA, you don't get a deduction, so it's technically, using after-tax dollars. A Roth is the same thing. Here's the key. All right, here's where you can make money, by the way, if you're in that situation. Okay, because what you can do is the non-deductible IRA, okay, the principal obviously is after-tax dollars. You don't pay any taxes on that. But what it earns, what that money earns, is taxable income when you take it out. Okay, why do you convert it then to a Roth? Same thing, basically, okay, is the principal is after-tax dollars. You don't pay any tax on that. But the income is tax exempt, folks. Not tax deferred, tax exempt. You don't pay any taxes on it. So all of a sudden, on the non-deductible IRA, 10 years from now, you take it out and you owe $5,000 of taxes on it. But if you convert it as a Roth, what do you owe? 0. Okay? Watch out for those Roths, okay? When they first came out, I tried to convince people. It is so hard sometimes because they can't see the forest for the trees a lot of times. And what happens is they said, oh, well, I don't get a deduction for that. I don't want that silly thing. I don't want that silly thing. But you keep it 5 years and wait until you're 59 and a half, all of it's tax-free. But they couldn't see that, okay? So, can make a mighty tasty, asset for you as well, too. So that's one of your tricks, okay, that you can do. Charlie, go on. Okay, what do we got here? Okay, that just has to do with the income exclusion, or the exclusion, or actually the phase out. Let me go over here. That's dear Emily. Okay, so the phase out. I don't even need my glasses on this one. Because actually it's changed, okay? On the IRAs, the phase out starts at $105,000 and phases completely out on $125,000, okay? If you are in a company plan. In other words, if you're in a company plan, IRS does not really want you to make, another contribution to an IRA and have that deductible as well. So what they're saying is if you make $125,000, they're not going to allow you to make that IRA contribution. Okay? So what can you do? I just told you. Make it non-deductible and switch it. Okay? Because the Roths are even higher than that. I think they're like $208,000. Yeah, $208,000 is the phase out. So what you have to watch out for some of these things. Like I said, it's just mind-boggling sometimes. And I should have told you before that whatever I say up here right now would be good for probably today. Okay, they're changing it right and left, folks. They're just changing right and left. So it's just a matter of keeping up with this stuff all the time. And I spend a lot of time in continuing education. Lynn? No. Uh-huh. That one depended on your income. In other words, if you had more income, okay, I forget what the amount was now. Yeah, 208. Yeah, if you had $208,000, so this is for higher income type people that could not do it because of their income. But they could do the non-deductible IRA and move it immediately to a Roth. Why? Because you don't want any earned income in there when you're making the transfer. Everybody got it? Okay. All righty. This just tells you here, okay, it's have to be 66 years old. And I need my glasses. That's what I need. Anyway, if you're under 66, okay, I think you can make up to 18. What's that say? 18 something, 18.4. Thank you very much. This is when you get older. Okay, very good. Hey, I can see now. Okay, this is the maximum earnings, okay, that you can make if you're under usually age 66, which is your normal retirement age now. You know, if you're born, what is it, Donna? Do you remember? Is it over 61 or something? 1960? Okay. So it could be, in other words, you need to check with Social Security, okay, or ask Donna. You know, it could be over 66 is when your full retirement age is. Yeah. Yeah. I don't think they hit 67 yet, but you can bet they're going to go to 70. You can bet on that. So you know. All right. So anyway, if you're under that, okay, you can make, and you're receiving Social Security, okay, you can make up to $18,240. Now, if you do that, you're going to pay $1 back to them for every $2 that you make over that $18,000. If you're in the year, okay, of your normal retirement age, which could be 66, it could be 66 in 4 months or whatever. Okay, if you're in that year, they're going to allow you to make up to $48,800. If you do more than that, you got the same problem. Okay, but that's pretty decent sum. So, yeah, okay there. Okay. Okay. Mm-hmm. Don't you love it? Well, sure to do. Sure to do. Yeah. Yeah. And if you don't watch it, okay, and you're single and you make, I think it's over 25,000, okay, then part of your Social Security becomes taxable as well. So, is there a double and triple taxation? Oh yeah, there is. Do you understand what I'm saying there? Okay. Yeah. Mm-hmm. Mm-hmm. And Medicare doesn't care how much you make, because what happens is they'll tax you at 1.45% for the rest of your life. If you make $1 million, they're still going to hit you with that. Okay. Fortunately, Medicare, okay, has a maximum that they can take out based on 137.7. Right. Exactly. You're right, Charlie. That's right. So far is what he said. Okay, so it's amazing. Go to the next one, Charlie. It's kind of blurry. Okay. Here's one I made up for you. Okay, let's suppose that basically, most of us are what we call the sandwich generation. Okay? Some of us can't get the kids out of the house at any age. Okay? And some of us are taking care of their parents. And that's a good thing. Don't get me wrong, that's a good thing, okay? They raised you, and now it's time to help them out too sometimes, because they were never told, anything about retirement or how to save and all that kind of stuff. Most of them thought that, Social Security was going to take care of them. Wrong, okay? So let's say that you do have some elderly parents, all right, and you can see the average up there of $7,200 per year, okay? That's the average. Okay, that all the people, okay, that do take care of their parents are paying at least that much, to upkeep for their parents. Now, okay, the dependency exemption. This is the key. Okay, do the people you are caring for earn over $4,300 per year? The reason why I said no, okay, is that if they do not earn that, okay, then they can still become your dependent. If they do earn it, then you can't take them. Now, what's the key word there? Very good, Marcia. Very good. Very good. She's seen me a lot. Okay. So, okay, what you have to watch out for is earned. Okay. Is interest and dividends earned? Is Social Security earned? When I say earned, I mean earned. I mean it's subject to self-employment tax or Social Security. Okay, so if they don't have any of those and they're just on Social Security, then you probably got a good bet. Okay, now do you provide more than 50% of their support? Okay, so you have to find that out. Okay, how much are they spending on their support versus you? Here's a little trick too, by the way. Suppose they get Social Security and they bank it all and live off of you. Pretty easy, isn't it? Yeah, you're paying more than 50% of their support. Okay, so another interesting part about it is, I think I have it up there somewhere, is let's say that you can prove that you provide more than 50% of one of the parents' support. Okay, what do you do there? Every check that you make out for them, dear mom, here's your contribution. Dear mom, here's your contribution. Dad doesn't get a thing. Because you can at least take one of them if you actually put that on your check. If you don't put it on a check, Iras doesn't care. You're not getting anything. Okay? So because you didn't actually state it on your check. So what happens? Okay, why I think this is good? Well, number one, God forbid that they have so much medical that you can use that on your itemized deduction schedule along with yours. Why? Because they're dependent. So that means, if you're paying for all their doctor bills, dentist bills, drugs, labs, everything, you can take that all, okay, on your itemized deduction because they are an exemption for you. Okay? The other thing that they're doing now is, you see where I have the child and dependent care credit there? Okay, I don't know why they wrote that. I typed it exactly like it's on there. 50%, for one is 50% of 8,000, 4,000. Okay, all right. 50% of 16,000, 8,000. So anyway, if you can get both of them, there's a possibility, okay, that you can get that much as a credit on your tax return if you can prove that you provide more than 50% of their support. Now, what's the difference between a deduction and a credit? Deduction is just based on whatever tax bracket you happen to be in. A credit is dollar for dollar. This is a credit. Okay, so you can either get it, off your taxes if you happen to owe taxes, or you can get it as a refund because it's refundable. Also, there's a child and dependent care credit. Congress is kind of still working on that, but it's a $500 credit in addition to what I just told you. So could be, lots of money. By the way, okay, let's say that the parent didn't get their stimulus check in 2021, which we're in right now. they should have gotten it. Okay, if they're your dependent, okay, you file your 2021 tax return with them as a dependent, and you put on there that you want your $1,400, please. Quite a bit of money there, isn't there? Okay, so next. All right, another one I made up. I should have made it bold or something, shouldn't I, Charlie, I guess? Should have made it bold when I typed it so you could see it. Anyway. Okay, qualified charitable distribution. Okay, this is a cutie here. And this is what a number of people do in this room, by the way. Okay, including yours truly. Okay, because most of us probably have our houses paid for. Okay, hopefully, God forbid, that you don't have much medical. So the only thing you have on there now as an itemized deduction is your charitable contributions. So what happens if you can use your charitable contributions and get the standard deduction, which is doubled? That's going to make you a bunch of money. Now, what we're talking about is the QCD, which is the Qualified Charitable Distribution. And what the law says is that you can go to your trustee, let's say it's Schwab, okay, or a mutual fund company, and you can say, okay, I want you to write a check out for me for $10,000 to Pine Castle United Methodist Church, okay, and make the check out to them. You can even send it to me, because even if I got it in the mail, I can't cash it. It's not made out to me. But you can do that, or you can send it directly to Pine Castle. Okay, but if you do that, two things happen. Okay, number one, that qualifies as an RMD, required minimum distribution. So if you're over now 72, is what the law changed to, by the way. If you're over 72 and you're required to make required minimum distributions, which means you have to take money out of your IRA, your SEP, or whatever it is, not a Roth, okay, but out of a taxable retirement plan, you take it out of there, okay, then it qualifies for your RMD requirement, okay, and, okay, it normally, if it went to you, what happens to it? It goes on the front of your 1040, doesn't it? Okay, on your individual or joint tax return. Okay, what happens to your Social Security? It increases your Social Security tax amount, doesn't it? When you do this, the qualified charitable deduction or distribution, it never shows up on the front of your 1040. Therefore, it's not taxable income or income, period, okay? And it doesn't raise your Social Security. So I've seen this happen a bunch of times. And I just go, woe is me. You know, why didn't you see me sooner? That type of thing, because you need to do this. But the requirement is that you have to do a trustee-to-trustee transfer, which means that you call, like Schwab, say, take money out of my IRA, okay, make it out to the church, all right? You can send it to me or send it to them, which doesn't make any difference, okay? But then you call Greg up and say, Greg, $10,000 is coming, okay? He's considered as a trustee here, okay? So it goes directly to him, and he credits you for that amount. It's done, folks. It's done. In other words, you've got a qualified charitable distribution. Doesn't go on your tax return, therefore, you don't have to have your Social Security benefits taxable. Marcia. Mm-hmm. Still in your pocket, huh? Yeah, yeah. That's right. Yeah, that's right. That's right. Mm-hmm. Sir. Oh, I'm sorry. I'm sorry. She said, and the money really stays in her pocket because she didn't, you know, she just sent it over like she was normally going to, well, let's back up. She normally was not going to do that, okay? The money the tithing had to come out of her pocket, didn't it? Now it doesn't have to come out of her pocket because she's taking it out of her IRA. She's qualifying it as a charitable distribution, and she's qualifying it for an RMD, required minimum distribution. So she gets to keep the money in her bank account, and she's taking it out of her IRA and doing everything that she's supposed to do with it. Now, I said to the church, it can be any charitable organization, okay, that's actually a charity. Okay, so you can do that as well. Okay, so, but I'm sure Pinecastle would appreciate it. So, okay, yes. Okay.
We have a question from our online audience. QCDs only apply after age 72 now?
That's correct. Yes. Yes. Okay. By the way, okay, bottom line right there, you can withdraw up to $100,000 any 1 year or all years, as long as you have that much in your IRA, that is. It would be nice you could draw it out and then you just give it to you, but, you know, but you are allowed to take up to $100,000 per year in this particular case. How long is this going to last? This has been going on for, I don't know, let's say 10, 12 years. Just recently, they made this permanent. Okay, every year when Congress was in session, in December, of course, when it didn't do you a whole lot of good, they would flip it back over to the next year. How would you know whether you qualified for it if they didn't make it, you know, a tax law in that particular year? But finally, they made it a permanent statute in the law. So you can do this now with confidence, and you can do it January for the entire year. Lynn? Mm-hmm. Correct. That's absolutely correct. Now, you're saying yourself, oh, I'm sorry. I'm sorry.
On your personal 1040, you do not take the QCD as a charitable deduction.
That is correct. Okay. What she's saying is that, you know, normally if you make a charitable contribution, it usually go on your Schedule A itemized deductions on there. You do not do that either. Okay. It's not income and it's not deductible. Okay. But you're saying, now wait a minute. I get a 1099-R on that. What the heck do I do with that thing? Okay. There's certain codes that you can use, which I know of, okay, that you can just put it on there. What's so interesting is I started this, I don't know, 7 years ago, somewhere like that. First 2 years, guess who got audited? Me, okay? All I had to do, when you do that, make sure that you make a copy of the check before you give it to the charity, okay? Because fortunately, I'm smart enough to do that, okay? And when I got the love letter from Iras, I just attached that and say, here, have this. And about a month or so later, I'd get back and say, no change, okay? That happened to me 2 years in a row, by the way. Now, and since then, I don't get any love letters anymore. I'm really hurt.
Another question from our online audience. Does all 100,000 have to go to charity?
It does not, but the part that doesn't is what? You got it. It's taxable. It's taxable. No, it doesn't say that you have to take every dime that you're taking out of that, you know, IRA, okay, has to go to charity. But the amount that does not go to charity, okay, is taxable income to you. And then what does it do? It increases your Social Security as well. So you get hit, you know, twice as much sometimes. I've seen it, you know, and it's really sad. It's really sad because didn't you already pay taxes on that Social Security? I thought so. Yeah, yeah. So that's what happens. Okay. Is that it, Charlie? Oh my goodness gracious. Okay. What time? Getting close. Okay. Okay. Good. Good. So, any other questions? I'll be around for a little bit. Probably Lynn will too. Oh, and by the way, Lynn has a questionnaire that she will give you. It's about a 10-page questionnaire. Okay, it has to do with, name, address, social security number, date of birth, where's your money, where's your, is everybody, do you have beneficiaries on everything? By the way, when you come to my office, okay, and I do an IRA or a SEP or whatever for you, you don't leave my office without having beneficiaries, okay? I've seen too many of them that they just want to get a commission, and all they do is rip through the paperwork, and then the person dies. And like Lynn said, the state, if you don't have a will, don't worry about it. The state has one for you. But anyway, this 10-page thing that she writes up and everything, and you have to put all that kind of stuff, this is mine. Going to Lynn. Yep. So we trust each other explicitly, okay? I've known her so long. She's a beautiful lady that does what she says she's going to do. And for that matter, I do too. So all we're here to do is to help you, okay? So if you have any questions, give me a holler, okay? Thank you.
Thank you, Keith, and thank you, Lynn. Appreciate y'all being here today. We do want to be in a position. We do want to give Caesar what's Caesar's, but that's all we want to give him. And we want to give God what's God's. And I think there's a proverb that says a good man leaves an inheritance for his children. So we just want to do it right. Thank both of you for being here. And let's pray and adjourn. Father, we thank you for this day. We thank you for the pearls of wisdom that have been shared, Father. We ask you to help us to recall and apply those that are useful to us. And we always want to do your will. We thank you again, Father, in Jesus' name. Amen. And I will send out copies of the presentations. Make sure your email is right. And I think we've got everybody that was online. I think we've got connections there. So we will send out a copy of all the slides. Thank you.